Great. Okay, so we'll get started on the subcommittee reports. Aimee, for the domestic violence committee, do you have a report to share?
Sure. So the report was in the minutes. The most important thing to announce is that the DV Conference Planning Committee is up and going, so that we're looking forward to having a DV conference in 2024 in person. So yay for that. DVCC met in May and had a report out, so we're still looking for more participation in the AIP subgroup, and we are continuing to push forward the animal subcommittee. What we know is that a lot of DV victims won't leave their pets, and that becomes a barrier. So that's one of the challenges that we're really committed to taking on. So we're going to really put forward some effort around that. But we look forward to folks being on the committee to help us plan that conference. All hands make light work, right? So thanks so much. Next DVCC meeting is going to be August 4th. We hope to see you.
Great. Do we have any questions or comments for Aimee on her report? So we'll move on to the forensic mental health work group. Tanya, do you have a
Good morning, everyone. So the only updates I have is that instead of having 15 people waiting to go to Maryland Department of Health hospitals, we have 13. And the detention center will be having a resource fair for sentenced offenders on Thursday. And basically, they'll get an opportunity to engage with some people and try to get some things set up prior to their release. So one thing I would like to ask, I don't know if this is the forum for this or not, but since I have everyone here, I might as well present it. So Baltimore County in a whole, we need to figure out a way how to handle our mental health elderly population. Because I have a guy on my mental health unit right now. He's 60-something years old, first incarceration. He cries every day, and in my opinion, jail is not the place for him. So I've communicated to the public defender's office about this, but collectively, we just need to figure out a way that we have a place for them to go other than detention. So I don't know if that's a topic for a later day, another committee or something like that, but we've got to do better with our elderly population in mental health.
What is he charged with?
Second-degree assault.
You
He
can call
scratched his
call.
wife by trying to knock her glasses off. He was having a manic episode and he scratched his wife.
Okay.
We have had a couple of people in the jail lately with some special needs, somebody hearing impaired, could not hear. Judge, you had that case on habeas, I think, recently.
Right.
So we are seeing it more at the public defender level in terms of who's coming into the jail. And it's coming up with, I don't know if you want to create a whole system around one person, but there are definitely special needs that I think, should start looking at across the board.
Sure, I know Walt Westerfield usually, he's the director of corrections, he's usually here for these meetings. Unfortunately, he had a family emergency this week, but I think we can pull him into that conversation and start looking at what's going on and what options there are, and include all the relevant partners in that conversation.
That makes sense.
Are there any other questions or comments for Tanya? Okay, so we can get started on our presentation. So again, today's topic is pretrial risk assessment and pretrial supervision. And we have 3 groups presenting today: DC Stat, District Court, and Circuit Court. So we'll turn it over to Momen and BC Stat.
Good morning, everyone. Just to sort of preface this presentation, we were asked to look at some of the pretrial process, the bail process, risk assessment score process, and so we began to do some preliminary analysis on some of the information, just as an FYI for everyone to see kind of some of the trends that we're seeing just generally in this specific process. And then the idea is that as you're looking at this presentation, you're going to have probably questions, and so obviously being able to then, it's a ton of data, and so to help us focus on the questions that you all have to be able to answer those specific questions. So as you're going through the presentation, if there's something you'd like to see differently or you'd be interested in, just feel free to chime in and let us know. So with that, I'll just jump right in. Sorry. So we're gonna do just a very, very quick little overview, and it's not even necessarily the process, it's just for those that aren't aware of the risk assessment system, how that works. General demographic information, we tried to analyze the information based on gender and race demographics, just as that's the first thing we start off when we're looking at any data set here in Baltimore County. And then the pretrial release risk instrument that's being used, how the scores and that breakdown occurs, and then bail amounts by the scores, and then some takeaways that we found interesting and some points of discussion. So a lot of jurisdictions use this type of pre-trial assessment tool. We're currently using Montgomery County's version of this tool, which they're still using, and again, it has different scores, but a low risk is 1 to 3, 4 to 8 is low. Lowest risk is 1 to 3, 4 to 8 is low, 9 to 12 moderate, and 13 plus is high risk. And we'll see some of those scores later on. And then pretty much we looked at some of the data in terms of bail granted, bail denied, appeal, etc., and then released on your own recognizance. So here's again just a breakdown of some of the factors that they considered, the risk items that are considered during this process. The previous offense, most serious previous offense, current legal status, severity of prior convictions. I'm not going to read through this whole list, but some of the other ones, even the gender of the individual plays a role in this risk assessment tool. And this is just a PDF sheet. I know it's hard to see. Usually this one works, the others projector works, but not today. So overview, just high level, this is everyone that is entered into the correctional facility in Baltimore County. Again, I want to be explicitly clear when we look at data that of all of this data, this is only individuals that have been incarcerated at our detention center here in Baltimore County. So if somebody had another incarceration at another facility, they would not show up in this data. So this is specifically Baltimore County Detention Center. You can see the breakdown is about 64% Black or African American of the individuals that have come in. White is about, it's kind of hard for me to see, but about 31, almost 32%. Gender, male, about 82%. Those are general because as you see the upcoming slides in terms of gender breakdowns by scores and by bail denied and bail reviewed, it puts the context there as well, provides some context. So overall, there's these different levels of bail award, and I'm sure most of you know these much more than I do, but appeal bond, obviously someone appealing that decision. Bail set is pretty much, that's your bail was set and that's what you took and honored in whatever way. Released on your own recognizance, there's 2 different levels for this. So there's the one where you're just released, obviously, and then level 1 is your call in. Level 2, you have to, it can be custom based on the individual, but you have some kind of physical check-in of some sort. So you can see the breakdown for the individuals that were denied a bail and then awarded bail based on those specific breakdowns. So the people awarded, how many were given, the majority are released on own recognizance level 2. And we do have it as a percentage breakdown of the total, so about 25% are released on their own recognizance level 2 when bail is awarded, 18% are released on their own recognizance, and then 11% actually appeal. And then on the bail denied side, you see about 26% bail set, 3% appeal. So by demographics, bail outcome, you can see here, so roughly about 45%, and this is of the total. I won't spend too much time on this slide, but just to say that roughly for just about every single race, it's about 30% get denied bail. It's almost identical between Black, African American, white, and the other race categories. It's about 70% get awarded bail. So then we broke it down by the risk assessment tool. So the risk assessment score. So this is just what this is showing, and I know it's kind of hard to see, and we can share it, but you can see that there's individuals that may have gotten -7, and then individuals who've gotten a high score of like 24. And you can see that, and usually the ones on the outliers, usually those are anomalies that can be like, you dig into them and find out sort of what's going on. But the idea of this chart is that the green just pretty much means that over 50% of anyone who's received that score was either awarded bail or denied bail. So the vast majority, over 50%, are awarded bail on pretty much all of the scores outside of, I think, 20. One of the interesting things, obviously, that we found was somebody with a score of 24 being awarded bail. But again, that could also just be one person, right? And so I don't want us to spend too much time thinking about the 24, but it's really the -1 to about 14, 15 is where the majority of the individuals are in terms of scores. And you can see that roughly about anyone who receives that score, roughly about 70% are being awarded bail. One of the interesting trends that we also saw is that range between 6 and 9 dips below 70%, which is a little interesting considering the fact that I would assume that the percentage of bail award would go down as you got a higher score, but that doesn't necessarily seem to be the case. But that's, again, just some information to put it out there and deal with it. So then, again, this is just a different breakdown of the same thing, just easier to see, Asian race, you can see that 71% were awarded bail, Black or African American, 70% are awarded bail, Hispanic, Latino, 67%, white, 70, almost 71% awarded. And then these are just in the chart format. And then this, again, I didn't realize how hard it was to see, but this is the average bail amount by score. So based on the bail assessment score that someone receives, this is the average bail amount that's usually set for that individual. And again, you see there's not really a sort of, I would say, anticipated increase as the scores get larger.
Can I just ask a quick question on that last slide? Does that say blank?
Yes, so outlier, we don't know why, we're looking into it, but this is exactly the reason why we review this data, to be able to find out what's going on. We actually found another issue, or I wouldn't call it an issue, but another thing that actually came up that was also interesting, but yes, we are looking into that blank and why there was not a bail assessment done for that individual. Again, with data, it's not always 100% perfect, and we always, yes, that's exactly what you're like, right? $4,000.
That's what I meant.
100%. Fair question, that's why we're here. So one of the other things that we also noticed is that there are individuals who are receiving bail assessment scores, but they may have 2 or 3 cases, and so they're getting a 2 or 3 different hearing dates, and then they're being released on their own recognizance for the first one, but they're still being held because they're waiting for those other 2. So this was an example of, for example, an individual who was booked on the 23rd, had his first hearing date on the 24th, but then had to wait till it was released based on that case, but then had to wait till the 24th, the 26th, 2 days later until that other case was decided. So we just thought that was interesting that we saw a good number of individuals that kind of had that same situation where they had to wait for their other pretrial hearing. And that's pretty much the end of the presentation. But some of the other things that we could potentially look at is the breakdown of the risk assessment of the bail denied and awarded by judge. We could look at based on recidivists and individuals that have previously been in that facility, and there's how that impacts their score. There's a ton of ways that we can go, but we just want to share this as what we can do with data, and if there's any support that you all need or questions you have, we can try to answer them to the best of our ability.
Does anyone have any questions for Momen or any ideas for other areas to look into that BC staff can look into for the next session?
How big were those, the one slide you had a list of the pretrial scores on the left. It's like halfway through, I think, and it basically listed scores from -7 all the way down to 24, I believe is what we had. How big are these subsets for like the score? I'm looking at the score of 0, and there's 41% that were bail denied at 0 with a score of 0. Do you know how big those sets are that you're looking
Like
at?
the total number of people that received? I can find out and share that.
That'd be great.
Absolutely.
Thank you.
Another question. Can we get this PowerPoint distributed to the members of this committee, or?
There's certain slides that I cannot share, but I can share some of them. So the demographic information, some of the score stuff, as long as there's obviously no personal identifying information, there's like maybe 2 of them that I don't feel comfortable sharing, but yes, definitely the takeaways.
Well, thank you, Momen. His team put a lot of work into getting this together, so we really appreciate it. So next up, District Court.
All right, good morning, everybody. I just want to do an overview of pretrial supervision from the district court's perspective and probably provide some history surrounding where we started, how we got to maybe where we are here. The bail process, I think in earnest, actually kind of starts at the district court level. If you are arrested, whether it's a felony, circuit court tribal charge, or whether it's a misdemeanor district court tribal charge, arrested by law enforcement, served with an arrest warrant, served with certain bench warrants, you appear before a district court commissioner who is an independent judicial officer and makes the first determination about bail. They might release the defendant, they might release with conditions, they might release only if the bail is posted or hold without bail. If an individual is denied bail or cannot post the bail, then they have a bail review in front of a district court judge. Looking at the FY 2022 statistics, those are the most current statistics that are fully available. The district court did about 7,800 bail reviews. Now that number does not match the number of people who've been charged with crimes because some people are released on summons, some people are released discretionary by officers who hand a citation. Some people actually get released through the commissioners at the initial appearance. They're released on their own recognizance. So 7,800 doesn't represent the total number of people who may have charges. That's just what appeared before a district court judge. That number breaks down to 7,300 approximately on criminal charges and 476 on must-appear traffic charges like DWI, DUI, fleeing and eluding. So the pretrial supervision program, at least in Baltimore County, got started back in 2017 as a result of justice reinvestment changes as well as bail reform. And it started with a work group that consisted of the Public Defender's Office was represented, the State's Attorney's Office was there, representatives from the jail, including pretrial supervision, task program, judges from the district and circuit court, staff from the circuit court. We had representatives towards the end from the county executive's office, and one person that I have to call by name because I don't really actually know what his job title was, but he was very much a point person to kind of coordinate and get all the information that we needed, and that was Randy Menzel. I don't know if many of you know him, remember him. Whatever he did, his job seemed to cut across all different departments within the detention center. He was very, very much involved in the work group that we had. We looked at Hartford County, St. Mary's County, Anne Arundel County, Baltimore City, and Montgomery County, looked at their risk assessment tools and their pretrial supervision programs, and picked Montgomery County because we thought that model would more accurately reflect the needs and address the concerns that we had here in Baltimore County. And we officially launched the pretrial supervision program in December of 2017. There was a press release, we had articles in the Sun paper, we had articles in the Advocate. We met with the Baltimore County Legislative Delegation, and we actually briefed the Criminal Justice Coordinating Council that existed at that time. And from that point on, we began to give meetings, updates to Criminal Justice Coordinating Council about how things were going with pretrial supervision. At the time we launched pretrial supervision, there was a program at the jail called the TASC program, Treatment Alternatives to Street Crimes, TASC. That program largely focused on supervising defendants who had drug offenses and had been convicted at trial and were placed on a Baltimore County probation, basically. And lots of judges really liked the TASC program. It was much more engaged with supervising individuals. They were more hands-on. Was just a really great program. But the thinking was, TASC is another form of probation. We have parole and probation, so why not maybe transfer some of the folks who were doing the TASC program into the pretrial supervision and let parole and probation pick up all of the supervision. So after some discussion, that's sort of what happened. A lot of the folks doing TASC got sort of transferred into pretrial supervision. We were able to attend a pretrial summit that Chief Judge Barbera put together, along with then Senator John Frosh and Delegate Kathleen Dumays. It was held in Annapolis. All jurisdictions around the state were invited to attend. There were representatives nationally who came and spoke. We had some local representatives who came and spoke to us about various pretrial issues. We learned after that summit that the governor's office had grant money available to help counties start pretrial supervision and to help them enhance the programs that were already going. So Baltimore County applied for grant money. We also reached out to an expert who had been working with Montgomery County, and that was Dr. James Austin. He had worked with Montgomery County to help them develop their program and was actively working with them to help them do their risk assessment analysis. So we had reached out to him, hoping that we would get the grant money to be able to have him do the risk assessment analysis for Baltimore County. Unfortunately, Baltimore County was not successful in securing that grant money. But we continued to reach out to Dr. Austin, and he was able to meet with us and provide some additional information and some guidance as to what things we might want to consider with regards to the pretrial program that was active at that time in Baltimore County. COVID then hit, and we stopped meeting. Everybody shut down. The world came to a halt. But at the point in time that COVID sort of ended at least our meetings, we were grappling with some issues that I think are still relevant even now. One of the biggest issues was home detention. There was a lot of concern around the fact that not as many defendants were deemed eligible for home detention. And back in the original iteration of the pretrial risk assessment, it was very restrictive in terms of who would be eligible for home detention. So working again with the jail, we were able to get some changes made to home detention, and I know that there are probably even more changes that have been made since then, and probably even some still on the horizon. Originally, the pretrial unit, the pretrial supervision unit, would give each judge at bail review a specific recommendation about what level of pretrial supervision the pretrial unit thought was appropriate, and would also give some recommended suggestions about what other conditions might be imposed. The work group kind of thought that was making judges feel limited in what they could do in terms of the outcome of bail. So the group made a determination to have the pretrial supervision unit no longer give those specific detailed recommendations, but simply to identify, as you saw on that chart, lowest risk, low, medium, high risk, thinking that that might encourage greater release of more individuals who really didn't probably need to have the level of pretrial supervision that I think sometimes we believed as judges would be necessary. There was a distinction between circuit and district in that circuit court would get written reports, but district court did not. So we talked around that issue. Should district court be receiving the same written reports from pretrial that circuit court was receiving? And district court decided no. We thought with volumes like 7,800 bail reviews, it was just going to be difficult for pretrial to get all that paper together, get it to the judges timely enough. And we felt that we were pretty good at the district court of just jotting down the relevant information that we thought we were hearing from pretrial supervision. Then IMDEC hit, and we had to deal with how do you work in IMDEC? How do you transition for cases that are misdemeanor charges where perhaps somebody's been held without bail? A lawyer may file a habeas petition to the circuit court. It now goes to the circuit court as a civil matter, no longer a criminal matter. And maybe the circuit court makes a different decision with regards to bail, places somebody on pretrial supervision. Now that case has got to come back to the district court. How are we going to make that transition smooth and seamless in the IMDEC world? So we worked around some of those issues. That kind of brings us up to where we are now in the district court. We currently have about 2,085 people that are on some form of pretrial supervision. Level 1 supervision, there's about 389. Level 2, 1,250. Level 3, 446. And that brings us to the point of the risk assessment tool. In speaking with my fellow colleagues at the district court, and I do the bail reviews as well, usually on Mondays or after a long weekend, we split the bail docket into 2 courtrooms because it's usually just too large for one courtroom to handle. So usually courtroom 1 and courtroom 6 will do bail reviews after a long weekend or closures because of weather or holidays. And many of the judges have expressed the concern, the need to have a risk assessment tool validated. And we all know sitting around that table that that's a thing that I know everybody would probably want to work towards. It really does help the judges have a level of confidence in the scores and the information that's being presented. Sometimes the judges have come and been uncertain about scores. They seem to be random. People who maybe judges think have violent crimes sometimes end up with very low risk scores. And there are various reasons for why that may happen. People who maybe have less violent crimes end up sometimes with very high risk scores. And again, there are lots of reasons for why that may happen. Sometimes it's not clear the consistency of how the score is calculated from one pretrial person to the next person. And this will come out at times when judges will ask, well, why is this person who's charged with trespass, why does this person have a score of 21? And someone, the pretrial person may say, you know, I didn't calculate that. I'm not sure how that was calculated. And sometimes we can have somebody at pretrial actually go through and recalculate while we're there in bail review. They put together another risk assessment score. So it's not always clear that there's consistency between each pretrial person who is using the current risk assessment tool. Home detention. We are frequently as judges told that a person is eligible for home detention, so we make that as our pretrial level 3 order, only to discover days later that in fact that person doesn't have a viable home plan. I can go back 20 years. I've been now doing this for 22 years as a judge, and when I first started, pretrial was live in person. We did bail reviews live in every court location in Baltimore County, and they would verify the defendant's address. They'd even verify whether the defendant was working. We'd get a summary of the probable cause. We'd get the record. We'd get the juvenile record. We'd learn about military, mental health, family ties. We don't get a verification of the address. Now, I realize our system has changed, and we now have public defenders mostly and private counsel involved in the bail review process. That was not the case back in those days when pretrial was giving us that information. But it feels like we've got the cart before the horse because we're determining somebody's eligible for home detention and then finding out 5 or 10 days later that they don't have a viable home plan. And maybe if we knew at the beginning that the home plan wasn't viable, we could make a different kind of a decision. We receive lots of noncompliance reports, and it's not clear whether the noncompliance reports are an indication that our risk assessment tool is not working, we're not capturing the risk and not adequately making an appropriate determination, or whether there are other factors that are feeding into the noncompliance reports. And of course, judges are split as to what to do about noncompliance. We realize that pretrial is not a limitless resource. There's a dedicated, limited number of staff. Should we be scheduling all of these for hearings and dragging people into court? Should we be issuing bench warrants and having lots of people picked up? It's really, again, this question of, does the risk assessment tool adequately evaluate the risk and give us appropriate information so that maybe we can avoid some of these non-compliance reports? And I'm going to throw this out there to the group. I know this is probably not the body to bring this up with, but I got everybody at the table, so I'm taking my shot, as they say. All right, that's my disclaimer. Statewide pretrial supervision. That really seems to me to be a thing to consider because we have statewide parole and probation, and that's what they do. They supervise people after they've been convicted. If you had a unit within parole and probation that's statewide, supervised on a pretrial basis, you could fund it. You could have cross-jurisdictional pretrial supervision so that if the defendant in front of me gets picked up in Baltimore County, but their charge is actually a case in Anne Arundel County, I could put them on a pretrial supervision statewide, and someone in Anne Arundel County could pick them up and supervise them. So I just throw that out there. I know this is not the right place, but you just got to take a shot every now and again. And I can tell you that this data, the statistics are available on the district court's website, on the Maryland Judiciary homepage. The pretrial summit, that webpage is still active for some of the information, so I'm happy to maybe provide a link to Lauren, who can maybe pass that around to the committee. And I can also provide you with the report that Dr. James Austin did on Montgomery County's risk assessment tool and their pretrial program. I can provide that
That'd be great.
electronically as well. So that's it for me.
Thank you, Judge.
Thank you very much.
Does anyone have any questions or comments for Judge Wilson?
I don't know about that statewide pretrial. Well, and again, that would be a big discussion,
That's
beyond
not
my
this- yeah.
level of, pay.
That's why I
But
threw it out.
I
knew
know.
you'd be here. I knew you'd be here.
because we actually just went through a big transition right before, at the start of COVID, related to pretrial across the state. That how the law is currently written, DPP is not supposed to have the pretrial, so you just have to change the law.
Right.
Right.
And I'm aware of one county in the state of Maryland that was doing
Right, a lot of
through
us
DPP
yes.
pretrial supervision
Right.
for a long time.
When I had what we call our West region, everything up 70 in Anne Arundel County, we were until our outgoing mayor, Secretary Green, made sure we were compliant with the law. So that's our only caveat to that. So, in that conversation, that part would have to be changed. Upbeat.
And either, coincidentally, I have the video pretrial bail review. I have a lot of friends waiting for me on the screen right now.
Judge, I sent the risk assessments to Linda. She has them.
Excellent. Have a good day, everybody.
So we'll move on to circuit court, Judge.
Good morning, everyone. So I want to thank Judge Wilson for that wonderful historical analysis. Even though I am older than her, she has much more institutional knowledge and has been very involved in that piece. And I support the idea of the validation of the risk assessment. And I thank Rebecca for reinvigorating this group, not only bringing it back in person, but making it more of a substantive group that's actually going to address problems as they come up, and there are many issues, and you've already highlighted some of them. So I'm going to turn it over to my lead criminal judge, Judge Cahill. Thank you for coming today.
Yeah, sure.
Just because of the people in this room besides Judge Wilson that has done bail reviews, you probably have done the most, and it can talk about your perspective in terms of pretrial assessment.
The circuit,
Brittany as well.
our jurisdiction is primarily by way of habeas corpus petitions that get filed after determination in the district court. So I do those like 3 days a week, mainly on the video screen. We split it up among 6 of us who do the criminal administrative docket. Everything that Dorothy referred to historically was great and accurate, and one of the neatest things that I saw happen was, and judges did like tasks. We all like tasks because there was a really robust effort to get these guys off the streets and into treatment. But when the county moved all those resources from task to pretrial services, it was wonderful. It worked very, very well. The pitch that I make is that home detention pretrial, I think, is the wave of the future. It's certainly the wave of the present. The statutes and the bail reform laws encourage us to use home monitoring as much as we can. Justin Halligan told me yesterday that the cost to the county of a home monitoring bracelet is $3.63 a day. It's $135.53 to hold a guy in the jail where they're likely to hurt each other. So to me, it's a no-brainer. We ought to be encouraging these level 3 releases. I think every judge prefers the county program over release on level 2 and then using a private home monitoring entity. But from what I understand, and I talk to pretrial folks pretty much weekly to see how things are going and about individual cases. The issue is staffing at the level 3 level. It takes a long, so like probably 60% of these guys lied to us about whether they have a place to live.
Shocking.
Yes.
They've all been thrown out of their mother's houses, and honestly, it's.
Yes.
Even when Jimmy's office does a great job of calling mom and saying, "Can he come back to live there?" We get terrible information. Now, Justin Halligan over at the detention center gets good information because they bird dog it and they make sure that before they release somebody, he or she has a place to live. So that in and of itself is a huge benefit to us because we're making a better decision because it's being verified that they have a place to live. It gets down to simple stuff like that. He needs more people over there at the level 3 because level 3 right now includes not only investigating a home plan for the person, but also monitoring the home detention situation. They got to call the cops and get a warrant if the guy goes off the reservation. It's intensive, the requirements that they have. And the last thing they do, unlike when we were relying on ASAP so much, is they prepare a warrant and perhaps an escape charge if the guy leaves the curtilage of his house and he's not supposed to. So that requires a lot of manpower. I think they rely a lot on retired correctional officers who are great, who work really hard at this stuff. But he just needs more money. He needs more staff. We need, in my judgment, what we need to do is like what we did when we moved task resources over to pretrial. We need to move more resources from the correctional services generally into that level 3. If we do, I promise you we'll use it. Every district court judge, every circuit court judge, we love it. I'd rather have the guy at home, with his mother paying for his meals than in the confines of a jail where there's COVID risks and there's a danger risk because they're slicing each other up with shivs. And so we all love it. We just want it to be pretty much perfect, which is, of course, not possible. But we haven't had any incidents since we switched over. In the old days, the county was very, they had a bunch of types of crimes that they wouldn't allow home detention through the county. We changed that, and it has worked wonderfully, I think. Now, right now, there's a limit of, I think, 250 people who can be on home detention through the jail. It's just, I don't know who imposed that, but
I think that's the number they came to with what they felt they could actually manage.
Yeah.
Because I think beyond that, they're spread too thin, and then that decreases the efficiency of the
he
program.
He used the term bursting at the seams,
Yep.
and I think that's primarily the people who do the home investigations. I just think it's smart money. We want to use it. The law requires us to consider using it, and as long as we can do it safely, we're going to rely on it. And I think it's the wave of the future. Holding these guys over there, especially, there's all sorts of complicated situations. If somebody gets charged with a gun in Baltimore City, you don't probation to me. I'm not letting him out. And I'm certainly not letting him out if I do let him out, I'm going to let him out on home detention. So there's all the different types of cases require different types of solutions. But I think home detention is one of the things that we need. Everybody needs to understand. It's just so much more smart from the standpoint of economic resources. So that's all I have to say. I think it's going very well from our perspective. We do get written reports every morning, so Judge Robinson will go over and get a copy of the guy's record. He'll get a copy of that risk assessment tool. And the thing about verifying this risk assessment tool, that word's in the statute. So I don't know that we're going to get better information if it gets verified, but I do know it's in the statute. Montgomery County's, I believe, was verified, right, Britt?
To my knowledge, yes.
Cost them $50,000.
That is what the old notes I found indicated. Yes.
I don't know what it means, but it is in the statute, and we like to follow the law when we can. So anyway, that's my report. I'm sanguine about the prospects for this. I think it's great. In terms of other observations that we've made over time, right today, there are 60 people sitting in our detention center who have Division of Corrections commitments, and they haven't been picked up and taken yet. So
I don't understand.
I don't either.
see that report, I'm not sure.
But that's a lot of people. And if one of those 60 gets hurt in our detention center and he or she was supposed to have been delivered to the DOC because my jail commitment, which is an order, says that they should be in the DOC, I don't know who's going to be responsible for that. I don't understand it though. It usually varies between 30 and 60 inmates. We've signed a jail commitment, 10 years in the Division of Corrections, and they sit over here for weeks. I don't like that. I don't think it's right. Probably ought to be looked at, at another level. Anyway, that's all I have. We always talk about. We used to have, when Dorothy and I were kids, we had what we referred to as a jail docket, which I thought was just wonderful. When I was a district court judge, we made great use of that. I think that we should continue to study whether or not we can move bodies through the detention center by having something akin to that, because it was really useful. It was, the cases, and a lot of that was a function of Randy. Randy, I didn't know Randy had a last name. I thought it was at the jail.
I still have Randy's cell phone number, so yeah.
But he's probably got yours.
Yeah, I'm sure, yeah.
He would pick up the phone and say, "This guy's been in for more time than he would have had to have served if he got the maximum sentence plus diminution credits. Can we get him out of there?" And we would say, "Yes. Let's have a docket for that." So it worked beautifully. I wish we could do it now. There seem to be some problems with MDEC compatibility, right?
Yes, it's a programming issue. We need to have certain codes programmed and identified that we asked for at the time we transitioned to MDEC. And there was not the money, I think, to pay for the additional programming.
It was sometimes I'll invite a public defender to go ahead and pray jury trials in 3 other cases to get them up in front of me the next day, because I know the guy needs to get out. That's not a good substitution for the jail docket. The jail docket was, I thought, really useful in
I agree.
managing the population of the detention center.
I agree.
If there's a way of doing it, I think it would be great. Anyway, that's all I had to say.
I will say for home detention, we have tried to add a few rehire positions to help with their workload, but I will work with Walt to see if in the next budget cycle we can really dig into building up that capacity, because I think he's done a great job of modifying some of the things within the program, and he's interested in expanding it. But as everyone I think in this room knows, the staffing is at a crisis level. Walt's done a fantastic job of kind of refocusing on recruitment, and we're starting to see that trend change, but it's going to take us some time to dig out of that. So I think maybe with the next budget cycle, we could look at focusing some more funds into that effort.
I'll just tell everybody, these gun cases, I mean, there are so many of them now, and it's rare that when you look at a gun guy who's got a prior gun, you're going to let him out. I mean, especially if it's a gun and a bag of weed and he's 18, he's going to kill somebody. So, there's more of we see more of those type of cases, I think, in bail reviews than we used to. And so the growing jail population, I think, is really a lot of it's a function of that. As I've watched things develop over the last 23 years, we just have more gun cases and less ability to let these guys out safely if they have a prior, or if there are other indications that they might be dangerous on the street.
Can you address your thoughts on the pretrial assessment tool and how you're using it, because you do so many of these?
Yeah, I don't use it that much. I look at it in every case, but it's an individualized decision that we all make. We've been making them for years. We have to assess dangerousness and flight risk together. Basically there are 9 factors, but we look at those 2 most prominently. I would like to see it comply with the law. I don't know if we'll be making better decisions if it does get verified, but I find it useful in some cases. I wish I had the guy who had 24. Who had that case?
Yeah.
Jimmy, you know?
I don't know. I do not know that one.
Anyhow, it's useful and it's helpful. But we go right to the criminal record and then work back from there when we're assessing information that we get, and whether or not the person has a reliable place to live.
So I think I'm going to ask or say a rhetorical statement. During COVID, obviously, all of our procedures changed. We got the jail census down to 750, right? From where it is right now, we're at 1160, I believe, or somewhere there about. We're pretty high right now.
Yeah.
So I think prior to COVID, we were at 1200. I am curious about that time when we released tons of people, right, on things that we would not have released people to prior to COVID, what either recidivism would have been during that time, what crimes of violence would have been during that time, what some of those stats would have shown. I know Chief McCullough would probably wonder how many of those guys that we released that we wouldn't have released prior were being rearrested, just because I think that would be a just kind of an interesting statistic for us to have, because if we were releasing more at that time and we weren't having this surge afterwards, was that COVID related or is that policy related? So
or could it be what led to 54 homicides in 2021, which is the most we've ever had. The most we've ever had.
I'd be curious to see like how many of those were releases based on that. But we know those releases, they would have been in the paper, right? We would have all been reading about Judge Cahill released some guy and he goes out and he kills someone.
That's why I didn't sleep for 16 months.
But I didn't hear of it, so I wasn't sure. So I'm just very curious about it. I understand Scott's position on this. I do, like in terms of where we are and stuff. But I do understand there is a rise in guns. There's no doubt. We see it in our office. I know both the courts have seen it in theirs.
Everybody's got a gun.
Yeah.
And a lot of that, we kept the jail population at bay by use of home detention. Also, I was running a Saturday docket for a while. John Cox came in. We would line guys up over at the detention center where there were easy cases. Somebody came into your office and we moved a lot of, we deferred disposition dates until we knew we were going to be open again. I was terrified that we were going to have outbreaks over there that were going to cause the hospitals to get overrun by people. So there were a lot of things that went into that reduction. It was a lot of work.
It was.
And it worked fine. Worked very well. I don't think we've had any major disasters.
No.
One guy.
Yeah, the only thing I want to add, just to give it some perspective, there are currently 200, as of yesterday, 201 inmates in home detention. Of that breakdown, 136 are circuit court and 65 are district court. So we're not quite at the max, right? But it used to be 50 or 60 tops, right? But because of your efforts to bring everybody to the table and change the criteria that the jail used for basically we didn't use home detention for years because nobody was eligible, so we stopped. But now you see the numbers have gone up because of the eligibility. But there's still, it's just a stat, as I just want to reiterate, since it won't be something I'll be focusing on in 4 days, is the resource issue and any support that you can get from the circuit court, from Judge Robinson or Judge Cahill. And Brittany Jackson is a data spreadsheet numbers person, so she can work miracles. And whatever data you need to help support additional budget requests, we're happy to do that.
Great, thank you. I appreciate that.
So I think we can give you some numbers because I don't have all the stats that you have because I didn't ask you to get those numbers. But we can get you those numbers and help get you the money that I think should be, as Judge Cahill said, a no-brainer. I mean, I think that's where the money for the correction should, not all of it, we still have to have a jail and keep people in jail.
Sure.
But I think we would use it more if you would allow more.
Okay.
And I think it's the wave of the future.
I think having that support from the bench will help as well in that budget request. So
You've got it. I mean, I know you have it, and you have it obviously from Judge Cahill, who's not leaving. He's going to be here for a bit, right? At least till next week. Right, at least till past Friday at 4:31. Judge Robinson's really young, so he's going to be here for a while longer. So I think you'll get the support of the bench, and whatever you need from us, don't call me, call Judge Robinson. And Judge Cahill and Brittany.
Thank you.
Yeah.
And that is inaccurate. When I look back at the stats, when we launched pretrial December of 2017, there were 30 people on pretrial home detention.
Yeah.
Now, what was it?
200.
200 and so.
As of yesterday. Yeah.
As of yesterday. So.
Yeah. But that's because of the change of criteria.
Yeah.
I mean, now we never used it, and now we do. Because of the change, because people are uncomfortable with the private home detention. They just don't have the ability, they have staff, I think, right? But they don't have.
I believe they do.
So I understand, but they don't have the ability to do the monitoring and pull people in as fast as the jail did.
Right.
So we just weren't comfortable with certain people on ASA.
I was not when I was a prosecutor either, so I get it.
Yeah.
It's like that was
Yeah.
not the company, but
Right.
but I'll definitely talk to Walt and see what we can do in the meantime. But then certainly in the next budget cycle, really focus on that.
So, and then the validation, that's something, again, above my pay grade, but that's something that is required by statute. It's not been done. I don't know if that's something can be done, where the money would come from. That 50,000 sounds like a
Well,
ridiculous amount of money.
It was.
But,
one of the things that people felt was that since it was validated in Montgomery County, therefore it's been validated. The issue, well, the issue is, these are different populations between Montgomery County and Baltimore County, and so does it have to be validated in each jurisdiction? So that was part of the discussion.
way back when, you mean?
Yes.
Yes.
I know.
Because you were there at the table then too.
Yeah, few years.
Under JRA, parole and probation has to revalidate every, I don't want to remember the year, I'll be wrong. But under JRA, it's required now that every, however many years, our risk assessments have to be revalidated. And we just went through that process.
Okay. Did it cost you $50,000?
Probably, yes.
Okay.
It was a lot.
Yeah, my understanding is it's pretty,
It's intense.
it's an intense process to validate it. So
Right.
I guess
And
that's
they,
what
and the
we have.
assessors will come out and sit with, whoever is actually performing the evaluation, the deal with inter-rater reliability and all of that stuff. So they spend a good amount of time with them.
Interesting. I think the other thing, Rebecca, to look at as you're reevaluating the pretrial program is, I don't know how many people are put on pretrial level 1. Anybody? When was the last time you used one?
Last time I set a monetary bill, which was 5 years ago.
Yeah, I mean, I don't know anybody, I have not heard of anybody setting bail. So I mean, it's either no bail, or it's home detention, or it's level 2.
We do still see a couple monetary bills.
Yeah,
We
you
do.
will.
Really? For what?
We will, out of district court
Out of
stuff,
district
we will
court
see it.
sometimes.
Okay.
I haven't seen it as much in circuit, but I do
Right.
see it in district.
Wow.
I have one come across my desk and the bill's at 2,500 or,
Really?
and now it could have been set by the commissioners, I don't, in terms of that, so. I'm not-
Yeah.
But it would be
So-
for you.
Well, when you look
Yeah.
at the bail numbers, they were all very low numbers. So, back in the day, we used to set bails. They were high bails, they were $1 million, 500,000, right? I still remember that. I set those. I can't remember the last time I did a bail when I've had the criminal admin docket. It's either none or home detention. So it's interesting that, so. Just something to look at is level 1. Do you use level 1 at all? in
Yes.
district court? You do?
Yes.
Okay.
Yes.
So you
that's-
do call in? Okay,
You
yeah.
do.
I don't think it's used a lot in circuit court, do you? No. I don't. I think it's 2 or 3. So, but if you're using 1, then,
We do.
Okay.
I mean, people who fail to appear, sometimes the charge is not one that you want to hold somebody
I
on,
got
but you just want to make sure that they
Call.
check in with
Got it.
somebody every
Okay.
now and again.
okay. So there's a reason to keep it.
Mhm.
Okay. That's my only thought. All right. That's all we got. So thank you, Rebecca, for what you've done for this group.
Sure. Thank you.
And in the future, I think great things are going to come out of this group.
Thank you for the presentations. This was very helpful as a starting point for the conversation. I know our next meeting, we have the second part of this conversation for the risk assessment tool. And in the meantime, I'll look into some home detention financial things and see if we can move some stuff around. And then we'll also start, I know that Lauren and I have kind of looked at, generally speaking, are there options for funding for the validation if we're going in that path, but we'll keep looking into that. If anyone in the room comes across something that you think is a funding source for that effort, then please feel free to reach out. I know we're over time.
We're tight on time, but instead of doing the roundtable updates, going through the list, we're just going to do it this way, where if you guys have something, just make a note of it. Shina Castain.
Shanae.
Shanae, I'm
It's
sorry.
okay, I'm used to it. The minister at my cousin's funeral on Saturday totally butchered it. But it's okay. Just real quick, for probation orders, our executive team was just asking if we could remind the judges to actually check if they're gonna waive the supervision fees. If that little wonderful box is not checked, then the agents or monitors have to write to request whether or not, we have to waive them, and we don't wanna add extra paperwork. So
Is that happening a lot?
it's just across all the jurisdictions. Some, like Baltimore County, is a little bit better than others. But they did ask that we bring that up at our CJCs. And that's it.
Thank you. Judge Wilson, you also marked yes. Did you have an update other than what you presented on?
I just wanted to let everybody at the table know that in my administrative staff, the chambers area, we're going to be down 3 people out of the 7 administrative assistants. One person got promoted, Chief Judge Morrissey took one of my people. I'm still smarting over that. And 2 have retired. So if you need something and you're finding you can't get to somebody, just be patient. Call Maria. Call Maria. Yes, call Maria.
Call me, I will
Call
give it to
Maria.
Judge Wilson if necessary.
Great, thank you. Okay, so next meeting is August 8th. We'll stay on this topic. The presenters will be the State's Attorney's Office, the Public Defender's Office, BCDC, and DJS. So it's a bigger group, so we'll try and keep the presentations around 10-ish minutes. And yeah, so if there's nothing further to discuss, do we have a motion to adjourn today's meeting?
So move.
I'll second.
Very good.
That's the routine.
Thank you. And please get breakfast.